So good morning again, ladies and gentlemen. We have a very interesting and controversial topic for discussion. Good, I'm sure it will generate a lot of heat. And we propose to, as a moderator, I have discussed with my panelists, and we believe that we each will have 15 minutes so that we have a reasonable amount of time for the interested audience here to share your views and ask questions so that we can have a real productive deliberation and discussion. So I have a distinguished panel. So we have Dr. Caleb Gabriel, who is a practicing patent attorney since 1980. He was a partner earlier in KNS, and now he has floated his own firm called Lex IP Care. Caleb has an extensive experience in handling prosecution as well as litigation. And we have next Dr. XVI, who has completed his PhD in synthetic and natural product organic chemistry from regional laboratories. He started his professional career in 1986, and he's now set up his own practice since 2008. Since 2008. And lastly, we had Dr. Marcus Engelhard here from Beaumont & Beaumont, who could not come here because apparently he wasn't well. So we are going to miss his exposition. But we have Professor V.C. Vivekanandan, who has received his PhD in intellectual property laws and holds his master's in corporate law and securities and master's in public administration. He is currently IP chair, professor of Ministry of HRD at Nalsar, director of Institute of Global Internet Governance and Advisory at Nalsar. So he teaches IPR there. So as you can see, we have a very instructive and a very learned panel. So take advantage of it and ask all the questions. As far as I'm concerned, I'm going to briefly introduce the subject and have some comments which I believe should be discussed by the panel here, and I hope is discussed by the audience here. So we are talking about innovator's investment, which leads to grant of the patent. And we all are aware that a patent, which is a culmination of an idea, investment, and invention, all three. And after the patent has been applied or granted, there is a lot of investment required ultimately before a patented product acquires success. So you have the research and development, you have human resource infrastructure, there are a lot of failures, there's just drug discovery, trials and approvals. And then there is a privilege which is granted to the patentee for the disclosure which he has made, and that is an exclusive monopoly, manufacturing, marketing, price fixation, licensing, royalties, and territories and everything, all those privileges which are given. So we appreciate that there is a privilege which is given because of the effort made by it. But the patent rights and the rewards also come with responsibility. And here we are talking about those responsibilities. So when we talk of compulsory license, we do talk of public interest, and that's a very common phrase which I hear all the time. Compulsory license is in public interest. And then I ask a question all the time, what is the patent for? Is patent not in public interest? And then let's be honest about that we are discussing two public interests. And we are trying to seek a balance between two public interests. And let it not be a private and monopolistic interest versus public interest, as a general perception is. Because if the patentee does not disclose the invention to the public, it will never be known. And it can always remain as a trade secret and can die with the patentee. And the benefit which the public will have by the disclosure will be deprived. So grant of a patent, in my understanding, is a grant in public interest. Now, that brings us to the issue here. What is the purpose of compulsory license? Because ultimately, every legislation has to achieve the purpose and the objective for which it was legislated. Now, though you will find very often the object and the reasons of a legislation defining the purpose, but we don't have to go that far. We can look into the provision itself, and Section 89 is very, very clear to define what is the purpose of a compulsory license. And if we read that, it says, the power of controller upon an application made under Section 84, which are the grounds for compulsory license, shall be exercised with a view to secure following general purpose. And that is to say, patented inventions are worked on a commercial scale in the territory of India without undue delay, and to, now till here there is no problem, to the fullest extent that is reasonably practicable. Please note the two qualifying terms in the purpose incorporated by the legislature. Working of the patented product on commercial scale to the fullest extent that is reasonably practicable. Practicable for whom? That's a question which I ask. Practicable to the patentee has to be, because it's the expectation is against the patentee to commercially exploit the patent. So reason, please note